Counsel, you're aware of what happened, that the appellee has submitted their case on brief, but you're here and we'll be happy to hear you. One caveat was you can't reserve any time for rebuttal.
Thank you, Your Honor. I was contacted by adversary counsel yesterday. He was not going to appear, and I'd already had planned to be here, and yes, the court was gracious enough previously to allow the argument to be rescheduled, so I thought I would appear, and I appreciate the court hearing me today. Your Honor, the brief I filed has raised 6 separate issues, but I think the issues on appeal really revolve around the trial court's failure to apply well-established rules of contract construction and interpreting the land sale contract that was at issue in this case. And in light of those issues, Your Honors, I would submit that the appellant is entitled to de novo review of the majority of the trial court's decision in this case, because I would submit to the court that the trial court's findings all revolve around in effect, the failure to interpret the contract. In essence, our position on appeal is that the trial court rewrote the contract, achieving a result that he apparently thought he sought to achieve, and we request that his decision be reversed and that the plaintiff's claim be dismissed and the counterclaim that was asserted below be reinstated by the court. Your Honors, I thought I would just give you a brief kind of timeline that might be helpful in considering these arguments. Is that the land sale contract was signed on December 19 of 2021, and April 25th of 12/19 of 09. On April 25th of 2011, there was an unusual storm in the Kingsport area. It had high winds, thunderstorms, and hail, and the residence in which the plaintiff resided was damaged. There was hail damage to the siding, a broken window, and a patio cover that was ripped off by the strong winds. The next day, the owner, Hickory Ridge, sent out a representative to review the damage and summarized it. The broken window was replaced. The siding that was blown off was covered by a plastic wrap or a moisture barrier. And the testimony at trial was that the plaintiff paid no monies for repairs to the home. He presented no evidence of any estimates for repairs or any evidence of how the outcome might have been different had the owner purchased a policy of insurance as opposed to self-insuring the property. The first lawsuit was filed in January of 2012. In October of 2012, the plaintiff abandoned the property and didn't make any further payments under the contract. And at that point, Hickory Ridge, the owner, elected to exercise its remedy to forfeit the land sale contract. And the plaintiff filed his second lawsuit in April of 2015. And that was the lawsuit that was ultimately tried before Judge Moody. At the time of trial, the only issues really that were remaining was the plaintiff's breach of contract action and Hickory Ridge's counterclaim for attorney's fees. Hickory Ridge, based on the contract, had elected not to try to collect the balance, but to forfeit the contract. And our position is the trial court decided that the contract was breached because Hickory Ridge failed to purchase a policy of insurance. And we would submit that that decision was both factually and legally incorrect. It was factually incorrect from the standpoint that the testimony was that the owner elected to self-insure the property as opposed to...
Counsel, what provision in the contract allowed the owner to do that?
The contract was really silent on that issue altogether. The only thing it speaks to is the fact that there was $60 a month collected by the owner from Mr. Leedy for insurance, but there wasn't any specific requirement that a policy of insurance be purchased.
Does it matter that the language says that buyer, of course, agrees to pay all insurance, which amount is included in the payment, and will be forwarded to the insurance company by seller? Does that not create an obligation for the seller to do that as opposed to being self-insured?
My answer would be that it doesn't specifically require that, but my answer would be, assuming it does, the question then becomes, how was Mr. Leedy harmed by the failure to do that? In other words, how was...
Well, his answer is, in the absence of an insurance policy, your client was the sole decider as to what were appropriate damages and remedies and fixes for the house, and what your client did was insufficient to properly get the house back into the condition it should have been in. It sort of puts your client in an interesting position, whereas as acting as self-insured, you know, I guess they get to determine how much and what to do to the house to put it back to the standard that it should have been in.
Well, the testimony at trial was that they did repair the window, they did do the wrap, the moisture barrier, and they were prepared to do the remaining work, but Mr. Leedy wouldn't allow them to do it. And there was a disagreement to the extent of the work that was done, and then he vacated the property. But I guess my point would be that the burden was always on him at trial to prove his damages. Now, what were his damages as a result of the failure to buy this insurance policy?
The house wasn't repaired. I mean, was there proof presented that the damage wasn't repaired? I mean, they put plastic wrap or moisture barrier. Does that repair the siding?
It wasn't a replacement of the siding, but there was never any evidence as what the cost of a repair
Well,
would
there was
be.
evidence that the siding wasn't replaced.
There was evidence that the siding wasn't replaced, but there was also evidence...
Was there evidence that the house, the roof, continued to leak?
There was evidence based on Mr. Leedy's testimony that there were leaks with the roof, but there was also evidence that he vacated the property, which essentially forfeits his right under the contract. And the important thing about that is the contract.
Counsel,
Question over here.
let me ask you a question, please. Who determines what is insured? In other words, if you've got an insurance contract, you read the contract. It says, I'm going to do this, I'm going to do that. Here, your client unilaterally decides it will self-insure. Self-insure what? What does that mean?
Well, that's a good question, because the contract is the risk of loss was always with Mr. Leedy. It was never...
Not when you say, I'm insuring.
Well, that's contradictory to the terms of the contract, but the contract also provided...
Who wrote the contract?
Well, my client prepared the contract. But,
So where does that put us?
well, that it puts us to interpret the terms of the contract as to what the four corners of the contract
Your
is.
client drafted the contract. Your client unilaterally decided that it would self-insure. You've got a plaintiff who says, I had this damage, still got this damage, and nobody ever fixed it.
Well, then he has to prove his damages. And that's what, if in fact that is a breach of the contract.
What do you mean he has to prove his damages?
Well, he's got to present evidence of the cost of the repairs, what it would take to put what damages he incurred as a result of a lack of an insurance policy on the property. So even if there was an insurance policy,
Well, you charged for an insurance policy.
I'm sorry?
Didn't your client charge for an insurance policy?
No, he collected money each month towards insurance that he...
Well, wait a minute. We're playing semantics here. Your client charged the plaintiff $60 a month for insurance. Your client decided it would self-insure. So was he insured? Was the plaintiff, the appellee, insured here?
By an insurance policy? No. By the commitment to...
I'm trying to figure out what the difference is here.
Well, I think the difference is, with an insurance policy, there's a third party involved that assesses the damages, and if there are policy proceeds available, they're made available to do the repairs. And I guess that's another point that I would make here. Even assuming that a policy would have been there would just have been proceeds available to the insured, my client, to make the repair. Mr. Leedy never had an insurable interest in the property. The owner was always going to be the insured, so...
Well, wasn't Mr. Levy paying for it?
He was paying for it, but he never proved what his loss was due to the absence of the insurance. And he elected to abandon the property, and he left, and he stopped making the payments. So I would suggest that is the result that should have been enforced by the court, was that he elected to leave. He didn't stay, where he could have, and then the contract has a specific provision that he could have notified the owner that the owner was in breach due to a lack of insurance, but he never did that. He just left without notice, and so that's the provision of the contract we submit that should have been enforced by the trial court. And I think also it's important to look at the means by which the trial judge assessed damages. The first element of damages that the trial judge assessed was essentially a refund of the grant that the owner had gotten on behalf of Mr. Leedy, the plaintiff, to enable him to finance the purchase of the home. And that grant was a federal grant that was made available to him. It was not any investment that he ever made in the residence. The trial court effectively just gave him that purchase price back. The second element had to do with his testimony that he spent $2,400 constructing a back deck or porch on the residence. Well, the contract provides that if he defaults, which he did, that he forfeits any improvements that he made to the property.
And if he didn't default, what is the contract? I mean, you're saying, you're making the assumption that, in the argument, I understand, you're saying that he defaulted, not your client. But, so, your argument there is premised on the fact that he defaulted, the buyer defaulted, correct?
Well, the contract provides a specific provision, and if the seller defaults, my client, that the buyer notifies them of the default and gives them the opportunity to cure. That never happened here. He just left. He just left. The testimony was undisputed on that. So, yes.
Did he not prevail upon, or did he not request these repairs to be made?
Well, he filed a lawsuit, and we were in the middle of litigation, so...
He hadn't requested it? Y'all hadn't had conversations? Or there's none of that evidence in the record that he informed your client of the problems he was experiencing?
Only with respect to the issue related to the roof. The dispute was that he wanted the roof replaced. My client thought it could be repaired. They never resolved that dispute, and he left. But that was the only thing that based on the evidence, that came up with on that issue. There were a lot of homes in this neighborhood that damaged, and the proof at trial shows they were spent in excess of $500,000 making the repairs. And they would have made the repairs had they given the opportunity to make the repairs. But
it's my understanding that there was testimony that because of the leak, there were moldy conditions inside the home. So is it your position that the buyer had an obligation to stay in the home until such time as the seller determined it would, I mean, how long does one have to stay in those conditions before they can declare your client to be in default and leave?
Well, I would answer that this way, Your Honor, was that he had to put him on notice specifically of this problem. There was really no notice of that issue until the trial.
Of the mold?
Yeah, yes, Your Honor. That never came up during the time period that the storm occurred and prior to he left. So that was an issue that was raised at trial. But my answer to your question is that he had to comply with the terms of the contract. And the contract required him to put him on notice, written notice of the problem, and give the seller the opportunity to cure.
So just to end this, so we should hold the buyer to the written terms of the contract in terms of notification, but we shouldn't hold the seller to the requirement that he is going to procure insurance.
Well, you would have to read that provision to say he was required to buy an insurance policy, and I would just respectfully disagree with that interpretation. Thank you.
Thank you, counsel. We appreciate your argument today and your brief on this.
Thank you.
Have a safe drive back.
Thank you, Judge.